what is the difference? The public inquiry seemed to side on the government on the use of the Emergencies Act, and now we have this latest decision saying it was unconstitutional.
There's a big fundamental difference between the two. So the Emergencies Act has a built-in review mechanism. There are two facets to that review mechanism. Within so many, I believe it's so many days within the invocation of the Act, there has to be established a joint parliamentary special committee set up to review the circumstances behind the invocation of the Act. That's a special committee composed of MPs of all parties, as well as a number of senators. So that has been ongoing, Jamie, for better part of 2.5 years. We have not completed it yet. We are still going through the draft report. So there is a mandate within the Act itself that the committee be established, as well as a commission be established. That could happen sort of at the same time, but as it worked out in this case, we heard almost 2 years worth of evidence before the commission was launched. Now, the Justice Rouleau Commission can make recommendations for the current government and future government to take with respect to the current piece of legislation, to strengthen it perhaps, or to consider amending it or creating a completely new act to contemplate the situations that existed here in Ottawa and around the nation. But it's not binding on the government. It is not a legally binding precedent. Now we know Justin Trudeau and his government took a victory lap, said, see, I told you, we were justified. But that is not the case. Justice Rouleau was not carrying the role of a justice to make that determination. His opinion was that the steps, the factors that went into the invocation of the Act were reasonable steps. All right? He wasn't required to weigh on whether the legal threshold had been met. And you also got to remember, Jamie, the opening words of Justice Rouleau's report, he also commented on this when he delivered this orally, is that reasonable people, upon reading this report, could easily come to the opposite conclusion that he did. So by no means was this an unequivocal endorsement of the actions of the Trudeau government. Now compare that to what happened in the federal court. We had two entities in Canada that launched an application for judicial review of the invocation of the Act, the Canadian Constitution Foundation and the Canadian Civil Liberties Association. A number of individuals were granted standing, also made representations. Justice Mosley had the benefit of reviewing all of the factors, all of the circumstances, but his mandate was very clear. His mandate was to determine whether that legal threshold was met by this government. Was there a national security emergency as defined by the Emergencies Act, and whether or not the actions taken by the Trudeau government were reasonable in the circumstances? He concluded unequivocally they were not.